you.
Gotcha.
Sorry about that.
All right, so Mr. Wilkerson has Romeo Johnson. Mr. Coleman? Thanks for running down.
Yes, ma'am.
It sounds like you literally did that.
Mr. Coleman.
Sorry, I just.
So. I just found, I was looking at the text as I was.
And what about Joel? Is Joel coming?
He was here and now.
Oh, yeah, that's right. All right, so you're Romeo Johnson.
Yes, ma'am.
And Mr. Johnson's cases are set for trial to begin with jury selection next Monday. Was the announcement?
We're ready, Your Honor.
Case ready for trial. Judge provided how the court rules on a certain issue, and that issue being we're going forward, or the state desires to go forward on the unlawful possession of firearm by felon. We have literally just two pieces of evidence for that trial, no witness testimony. The evidence, one of the pieces of evidence we want to introduce is a surveillance video that was introduced during the murder trial. The court will recall that this defendant was found not guilty in, and that the surveillance video shows what appears to be the defendant in possession of the firearm. The sponsoring witness of that video is out of the country and will be out of the country for a month. Under Rule 804 of the Texas Rules of Evidence, I believe the state can use the prior testimony of that sponsoring witness because it was subject to cross-examination by defense counsel. We have secured a transcript of that witness's testimony. We provide a copy of that transcript to Mr. Wilkerson, and we would, if the court will allow us to use that transcript, then there's no need for a continuance, and we'd be ready to proceed with trial.
And, Your Honor, I didn't come prepared to argue that this is the first learning of that unavailability unless Mr. Coleman sent me something yesterday.
I don't see anything. There was I guess, just recently filed a notice of intent to introduce transcribed testimony.
I did file that, Judge, with regard to not only the surveillance video, but also with regard to the defendant's own testimony as well. The court will recall he took the stand and essentially admitted to possessing a firearm that day.
Which murder trial was that? Remind me what I'm...
Romeo Johnson murder trial. It was, the complaint was, the victim was one of the twin brothers, Ronald Barnes.
Yeah.
I can't remember.
Oh, yeah.
You recall the brother was in the wheelchair that testified on behalf. With regard to this,
Give me just a second.
Ronald and Donald Barnes.
Yeah.
And Judge, I know you're reading, but Mr. Freeze or Judge Freeze did tell me to let you know we're in a 2-day trial.
No. Take me just a second.
Yes, Your Honor.
I don't know that this would...
My interpretation.
I mean, under 5, so 804A5.
804B, I think is what I'm referring to.
Well, first is A is the criteria for being unavailable.
True.
So a declarant's considered to be unavailable if. So you've got to get one of those 5 to be unavailable. Then you go to B. So it's not 1, 2, 3, or 4. So 5 would be the only one possibly. It states that is absent from the trial or hearing, and the statement's proponent has not been able by process or other reasonable means to procure the declarant's attendance or testimony.
And that is what we're hanging our hat on, Judge. My investigator, Mr. Bass, is here to testify on the efforts that the state has endeavored in to secure the presence of the sponsor.
Okay.
And I represent to the court that we've been unable, despite our best efforts, to secure the presence of evidence, given the fact that he's out of the country.
And so, all right, so if we're gonna get into that, we'll wait and do it at another time. I'll either lunch or like tomorrow morning or something.
Yes, sir.
Because I need to this is probably, we're down to maybe 2 cases. So I will need to make that decision and number the cases. So let's do this, because I would need to hear that information. I think I want to look up a little case law just to make sure. And so you've got one witness.
No witness at all, Judge.
No, one witness that's unavailable,
Yes.
and that witness would be sponsor.
The surveillance video that purportedly shows the defendant possessing the firearm.
And then
And the other piece of evidence would be the defendant's own testimony. For claiming purposes, Judge, I suspect this trial, at least the state's portion of the trial.
I just feel like without reading that, and I've never had this come up, where in his own trial, introducing testimony seems to violate the Fifth Amendment to me.
I don't follow the judge.
Well, I mean, it's almost like you're forcing him to testify
It's a
by
prior-
under on prior. I don't know, let me
it's a
look
prior
into that.
Statement by party opponent, Judge. I mean, he's admitted from the stand under.
I just need to do some
Under oath.
research that if it's I know if it's another party potentially, it talks about when it's a criminal case, what's given as a witness at a trial or hearing of the current or a different proceeding and is now offered against a party.
I mean, he very well could have asserted his Fifth Amendment right during that trial, and he did not, Judge.
Okay,
He made-
let me look into that. You look into that as well. So
Yes.
804, it looks like we've got 2 things. One is under A with regard to the unavailable
Yes, Your Honor.
witness. The other is under B, which is the former testimony of your client. So let's, I'll give you an opportunity. About how long do you think you guys will be going?
We anticipate finishing this afternoon, Judge. I could come back on the lunch break, or
No. You're in the middle of a trial. I don't want you to have to think about this and do that. I will number the cases tomorrow morning. So let's take care of this. Are you available to come? It won't take long. That gives me some time this afternoon to also do a little research.
I've got another case in the 317th, oddly enough, but I think I can kind of delay that.
If you can come
case
here
to-
first.
Yes, Your Honor.
It won't take us longer than, it'll take 15 minutes. I mean, there's really, I'm assuming your investigator, it will be quick to testimony as to the unavailability. The other is just legal issues that we all need to just look into.
I'll ask for a trade out since I couldn't stay
Perfect.
here today.
All right, so head back down there. We'll get you back over here tomorrow morning, 9 o'clock.
All right, thank you,
Okay,
Judge.
sounds good. And if everybody gets here a little early, we can start early. I'll try to be here early as well. All right, go back with the bailiff. We'll see you tomorrow.
Come back tomorrow?
Yes, sir, you'll come back tomorrow, and that way we know what's going on for sure if you're going to trial or not. Yes, sir. Okay, so I need to look into those issues. 804. Okay. And so let's see. 9. Mr. Smith, you have Derek Green. Mr. Bruce Smith. Morning. Thanks, sir. Good morning. Are you Derek Green?
Yes, ma'am.
And will your client waive the formal reading of the indictment?
Yes, Your Honor.
It looks like we're going on lesser, correct?
Yes, Your Honor.
I'm getting there, sorry. All right, Mr. Green, in cause number 25 DCCR 1119, the state has elected to proceed on count 1 only, and in that count, to the lesser included offense of a Class B misdemeanor terroristic threat from June 19th of 2025. And how do you plead to that charge? And are you pleading guilty freely and voluntarily? And because you did what they've charged you with? I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Smith?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And are you a U.S. citizen?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Green is not competent?
No objection.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of your plea, find sufficient evidence to find you guilty, and at this time, find you guilty of the lesser offense of a Class B misdemeanor terroristic threat, sentence you in accordance with your agreement to a term of 150 days in the Jefferson County Jail. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows this was an agreement that I followed, so you have waived your right to appeal. All right, good luck to you, sir. You can go back with the bailiff. Thank you. Thanks.
Thank you, Your Honor.
Oh, Mr. Smith, we need the attachment because it'll get closed out today.
Are you trying to?
I was in Orange at a super aggravated, and at the last minute, they
Yeah.
offered 10 deferred, so we
We
came
just need it
directly here.
emailed, we need it emailed,
But we'll email it, we've done that.
today, yeah.
Yeah.
Okay, I was gonna say, if you
And I
want
was
to-
like, I don't know which one to talk to.
It's looking like, all right, let's get Andre Williams, please.
Good morning, Your Honor.
Good morning.
Good morning, sir.
Remember?
I didn't say good morning to you. That's
No.
actually I've been here all along.
Oh, yeah, we've been, at some point, we gotta go forward. All right, you're Andre Williams. And so Mr. Williams' case is set for trial to begin with jury selection Monday. Announcements?
Judge, I've talked to Mr. Nichols. I'm asking for 30 days. I finally got some clarification on the Social Security records that I'm trying to obtain. They told me how to do it. They'll either let me know they're ready, I send them an invoice, if they'll give them to me. They'll certify them, they'll make them court admissible. The court doesn't have to, nothing about an order from this court or a writ or anything like that. They told me it may take up to 90 days, and that was 60 days ago when I think I finally got on the right track with them. So I'll know something, if I don't have them then I just.
I mean, and you believe that they're necessary
I think
for
that
the
they-
trial?
I think, like as the court pointed out last time, they may be necessary in mitigating circumstances.
Mr. Nichols?
Mr. Vasquez has kept me up to date on his efforts there, Judge, and we've discussed trying to resolve the case as quickly as we can. At this point.
And I guess, would the state at trial be going on the murder?
Yes, Your Honor, that's my intent.
Okay. Does that, I don't want to wait for all of this
No, Judge. we
for
don't-
mitigation on a murder if you elect to go on
No,
the other.
we're going forward on the murder.
Okay, all right, so I will reset, it will be on the next trial docket, which should be more than enough time. That's about 75 to 90 days-ish for our trial dockets. And then at that point, it'll be time.
Thank
It's
you.
getting old and it'll be time to get the case taken care of. Okay? All right, and as always, I've said, if you need any help, let me know.
Thank you, Judge.
All right, thank you.
Thank you, Your Honor.
You can go back with the bailiff.
Thank you, Luke.
Yes, sir.